Our sibling agencies are New Haven Legal Assistance and Greater Hartford Legal Aid. They cover those portions of the state. We cover the balance of the state. So that includes Fairfield County. We're in cities, we're in rural areas. So we cover about, I would say, 56% of Connecticut. So just a little about CLS. We provide access to justice for low-income individuals and families. And we only do civil side of things. So if you think about public defenders, that's our counterparts on the criminal side. We cover the civil side. To be eligible for services, however, for legal services, you have to qualify. It's really for low income individuals and families. So it is based on 125% of the federal poverty guidelines, which is, like a family of four. It's about, I would say, it's around 30,000. So very low income. And then it also has to qualify in terms of a practice area that we cover. Obviously, housing is a big one. I would say that's our biggest unit right now, followed by the family unit that does custody and visitation cases. In our housing practice, we right now it's solely dedicated to eviction cases. We also have a children at risk unit for special education matters. We have a public benefits unit that also does Social Security work. If anyone's denied Social Security benefits, they can come to us for assistance with that. And finally, we have an elder law unit that assists anyone who's 60 or older in a variety of matters. Could be housing, could be benefits, but also like nursing home discharge cases, for example. And the way that folks access us is they can call us directly or they can contact statewide legal services. The number is here on the screen. That is the hotline for the state of Connecticut. It's like the entry point, I would say, to see if someone qualifies for legal aid. And if you do qualify and it's one of our areas, they will refer it to the local office. And then this is just a listing of our 7 offices throughout the state. I work out of our New Britain office. There we go. So these are just some helpful resources. CT Law Help. If you want information on just about most civil legal matters, you can check out CT Law Help. It has a lot of useful information. So I encourage you to just browse through it. We have a lot of pamphlets online that will give you a lot of good information. There's also, I put the link to the judicial department. So in housing, our attorneys, that's how they track cases. They track them right on the website. But you can also find really good booklets and information as well that judicial puts out. So it's always worth it to check that out. There is also 211, which is the info line for Connecticut. It can be accessed over the phone simply by dialing 211, or you can access it online as well. And then this may be, I would think, of interest to folks if you're looking for an apartment after graduation. cthousingsearch.org is a really good website to kind of start searching. So I wanted to just kick it off, and I'm hoping folks will use the chat feature to answer some of these just to see where everyone's at with what they think the law is in Connecticut. The first one is, do you have a lease if nothing is in writing? If folks want to put an answer in the chat, I will look out for that. So that's question one, if you want to just answer it as question one. The other question to think about is, how long do you have to pay rent before it's late? Let's see. The third one is, does the landlord have to give a receipt? Fourth being, can the landlord change the locks and prevent you from entering the apartment? And finally, can a tenant withhold rent to get repairs? So I see someone put no for the lease question. Thank you for that. Feel free to answer some or, one or two of them just to see where everyone's at. And we're going to be covering all these topics as we continue through the slides. All right, I'll keep moving us forward. So we're going to start with leases. You actually can have an oral lease in the state of Connecticut. It doesn't have to be written. it can be month to month. So if you don't have a written lease with your landlord, it's considered a month to month oral lease. But here's a flip side of that. If it's not in writing, that means that the landlord can raise the rent each month because every month is a new lease. So if you're going to be someplace long term, that's not an ideal situation to be in a oral month to month. And however, if you want to move fast because maybe you're looking for a house or you might be moving in with roommates and you're just waiting for someone to finish up a lease, that might work well for you because you can move out at the end of the month and you don't need to give notice because it's just a new month, new lease, and you can move out at the end. The other thing is if it's an oral lease, the landlord cannot charge late fees or attorney's fees if they have to take you to court to try to get you out of the apartment. On the flip side, you have a written lease, which is, I would say, more common. The written lease is going to be for a fixed amount of time and for a fixed rent for that time period. So if you know I'm going to be in, for example, Hartford for a year after graduation, you might have some kind of job lined up. A year will work out great. You could do that and you know exactly what you're paying, and they can't increase your rent during the term of the lease. However, if you break the lease, then you would be liable for the remainder of the rent. And also in a written lease, a landlord can include late charges for being late on your rent. And we'll talk about that also about when you're actually late on the rent. They can also put in language about payment for fees if they have to evict you. And we're also going to cover that too about what that looks like. So one of the questions was, can the landlord just enter the apartment and put you out if you don't pay the rent? The answer is no. That's considered a lockout and it is illegal in the state of Connecticut. These references and parentheses are for Connecticut general statutes. That's where you can find the language, but only a judge can issue an order to get someone out. And a lockout is a criminal offense. I've had many clients over the years who have come in and either the landlord threw all of their belongings out or they changed the locks on them, all illegal. They can be arrested for this. But what a person should do if they find themselves in this situation, in addition to contacting a lawyer, I would say call the police immediately because you do have to document everything. There is a lockout, also known as an entry and detainer action, that can be brought. There's even forms on judicial website. But I would say if someone was unfortunately in that situation, they should definitely try to seek counsel because there is a lot to navigate there. But the landlord would be responsible for damages. So we've had lockouts where then the landlord had to pay money to our clients because they had to recoup some of what they lost. And to put it into some context, if you think about, just look around at your dorm room. Imagine if you had no access to all your stuff and you had to write it all down. It's pretty daunting. I've had clients lose things in 2 and 3 bedrooms and then had to sit there and itemize everything. It's a really hard thing to do. I know personally I couldn't do it. It's pretty daunting, but it does happen. Not as much as I would say many years ago, but unfortunately lockouts still do happen and they're illegal. So paying rent. Paying rent in the state of Connecticut, you get actually a 9-day grace period. If your rent is due typically on the first of the month, that means you get 9 days after that. So that gets you to the 10th of each month. So that means you're not late until the 11th. And if it's a week lease, you have a 4-day statutory grace period. So that in that instance, it wouldn't be until, so if it's due Monday, you have until Friday. If you don't pay by Friday, then Saturday you could be facing an eviction, they can move forward on it. How you pay your rent, it's going to come down to the terms that you worked out with your landlord. Either you're going to pay at the apartment or the place. If there's no agreement, generally it's at the dwelling unit. You can pay by cash, check, or money order. We always advise, write in the memo line, the rent is in full for the month of whatever it is. It sounds obvious, but it's a very important thing to do because we've seen clients get backed up and not pay rent. And so what happens is the way the landlord's applying their payments, it's showing they're not paying the month they're in, and maybe they did pay the month they're in, but they just couldn't pay January, for example. It does get a little technical, but it is important to write what month it's that you're paying for. I don't ever advise paying a landlord by cash, but I recognize there are some times where folks, you need to pay by cash. So if you do need to pay by cash, the law in Connecticut is clear that you're entitled to get a receipt. And I included the Connecticut general statutes in the parentheses, the law that says that. So on the limited occasion of paying cash, the landlord has to give a receipt. And the other advice I always give is keep receipts, especially around security deposit, because we're going to talk about that as well, like how to get back your security deposit. But make sure you keep all those rent, money order, and check receipts, just if there's any disputes, so you'll have all the proof that you need. So as far as landlord's rules and regulations, tenants have to have written notice of things, and it has to be clear, has to be reasonable. And if there's any changes after you sign the lease, it's not going to be in effect unless the tenant agrees in writing. I noted here the Fair Housing Act limitations. We'll cover a little bit. I'll mention more about the Fair Housing Act, but what I mean by that is there can't be anything discriminatory would not be valid, in other words. And we'll talk about what are protected classes, but there are some limitations about what they can't put in a lease. And then they can also have rules, right, that tenants have to follow. And if a tenant doesn't follow the rule, that could be a ground for eviction. Landlords are responsible for keeping, complying with health and building codes. They have to make repairs to keep it livable. That includes all the main systems, heating, electrical, and plumbing. Peeling paint is a big one too for anyone under the age 6 and under. So they would be responsible as well for removing the lead if there was lead in the unit. I put a note here about being careful. So this is where I've seen a lot of renters get in trouble. They'll say, oh, well, the landlord didn't come fix this leaky sink. Let's say you've got a faucet that's leaking. The landlord's been notified but hasn't come out. The tenant then decides, I'm going to withhold the rent. The reason that gets a little tricky is because in the state of Connecticut, it's very limited times when you can just engage in that, and it has to be for a serious essential service. There is another route you can take without doing that and then risking the landlord trying to evict you for failure to pay the rent. And we're going to talk about that other option in a moment. But to continue on with landlord responsibilities, they have to provide water, heating, electric. If they don't fix it promptly, the tenant can fix it on their own and keep receipts. That's important too. And a tenant may also move to temporary housing, or they can complain to the health officials. I always advise start with the landlord first. If you have an issue, go directly to your landlord. Put it in writing. Nowadays, folks text everything. That's a form of written communication. Save the text message. If a lot of time passes, it's actually 21 days, you have an option to go and file, to have the city come inspect and then file your own case into court, and we'll talk a little bit about that. But before you get to that point, you should always try to take these steps first with the landlord. Utilities, the landlord can't interfere with your use of utilities, and the tenant must have exclusive use of their own utilities. And let me give an example of that. It is not uncommon. I've had many clients over the years where, let's say they're renting in a 2-family home. They're renting upstairs and they have a neighbor downstairs. Because it's a 2-family home and 2 apartments, there should be 3 electrical meters. The reason for that is because you need common areas to have their own meter. If there isn't a separate meter for a common area, that means that one of the tenants is paying for it. So just be very mindful of that, because that is commingled utilities, and that's like a big no-no. They're not supposed to do that, but it happens so often. So just something to be on the lookout for if you're looking at places. Make sure there's not only enough electrical meters for each apartment, but also a separate one for common areas. And if you have any questions throughout any of this, please go ahead and feel free to unmute and ask or use the chat function. Lori was going to be tracking that as well. Otherwise, I'll keep moving forward, but I'm happy to answer any questions you may have during. So what are the consequences if the landlord fails to maintain your unit? Remember, I mentioned there is that other option that you can go into court without just withholding rent. If they don't make the repairs within 21 days of filing a complaint to health officials, you can file an action in housing court. There are some rules around it. You can't be in a position where an eviction was already started against you, which is where it says notice to quit. That's the first step in an eviction. And in a payment into court action, which is also called housing code enforcement, you as the tenant now pay the rent to court. And then the court monitors the repairs. And then at the end of the case, the court decides where the money goes. Maybe they decide some of the rent money does go to the landlord because the landlord complied. Or maybe they decide, the landlord didn't do what they needed to do and the tenant should get all their money back. But this is only a good option if the tenant can still afford to pay the rent and they want to stay there. Because remember, you got to pay it every month faithfully to the court. And if you don't, then you risk your case being dismissed. Another thing a tenant can do is they can end a lease by following the procedures in 47A-12. There has to be written notice of breach and then 15 days to correct. So if there's an issue, whatever the issue is, you put it in writing, there's a 15-day cure period. There are fines and criminal complaints by code officers for any violations. So just something to keep in mind. So what are tenant responsibilities? A very important one, of course, is going to be pay the rent on time. And as we talked about, usually you have until the 10th of the month. You're going to want to make sure that you yourself are obeying any housing codes. You got to keep things clean and safe. You do want to make sure you follow your lease obligations and obey written landlord rules. Allow others peaceful enjoyment of the premises and not engage in criminal activities. So let's say there's something in the rules about, no loud noise after 10 p.m. You do want to comply with that, because if you don't, you risk that you're violating either a rule of the landlord or the lease itself, and that may be grounds for an eviction, fines, or even criminal charges. Rent increases. So I mentioned a little earlier, they may be raised at the end of a lease term, but if you don't agree with the increase, you should continue to pay the old rent and explain in writing why you don't agree with the increase. A word of caution with a rent increase, the law in Connecticut is a little bit, it's not as clear as I wish it were. It has to be reasonable, right? So what's reasonable? There's a whole statute that talks about 13 criteria they look at. They look at the size of the unit, how much improvement was made to the unit. They look at things like how much other apartments of similar size go for to figure out the reasonable tests. There are now more fair rent commissions in towns, like Hartford has one, for example. You could go there. You can file a complaint right there now and just challenge it and have them look at it. But remember, at that same time, you should still be paying the old rent so that you don't find yourself defending a non-payment eviction while you're also disputing a rent increase. I did have a 2-day trial once, actually, of a tenant who didn't agree with the rent increase. I advised them to settle. It was a very small increase. They hadn't had one in like 3 or 5 years. The client really wanted to go forward. And unfortunately, we did go forward and we lost because the court found it was a reasonable amount of rent that they were asking in the increase. So these are all things just to keep in mind. And there's also extra protections for anyone who is 62 or older or disabled. And disability could be physical or mental health disability. They included mental health disability. They changed that. It's been over a decade now. But the other piece is you have to have at least 5 rental units. So if the landlord is operating at least 5 units and the person qualifies either by age or disability, they can also file an action in court challenging the increase because they get additional protections. So when can a landlord enter your apartment? For emergencies, they can enter without notice. But beyond that, a landlord just can't decide to come in and check on things. They just can't do that. And in fact, it subjects them to financial obligation to the tenant. They may have to pay like up to 2 months worth of rent to the tenant. I've had landlords over the years that would just go into the apartment and I would send them a letter and cite the law and tell them basically to stop their behavior, because if they did it again, we could go into court and then it'll cost them money. And usually that has helped stop landlords from doing that. Sometimes it's simply they just don't even realize they can't do that. They can inspect the unit and do repairs, but they have to give reasonable notice, and it has to be like a reasonable time. There's a theme here with Connecticut. Connecticut likes the term reasonable. There's no hard and fast rules about this. So again, it can get a little tricky. But if either the landlord or the tenant misuses the right to enter, the person can file an action in court to stop it and get damages. There are some additional protections for tenants in foreclosed properties. We saw a lot of this after 2009, but I guess the main points that I want to make about that is that if you ever find yourself in a foreclosed property, and it could be as simple as you're renting an apartment, the landlord is not paying the mortgage, and then the property goes into foreclosure. So if you have a lease, they have to the bank that now owns it after foreclosure has to give at least 90-day notice. And if you have a written lease, they have to let you stay until the end. The protections only apply to bona fide leases and tenancies. So the tenant can't be related to the person who had the mortgage, right? It can't be the child's spouse or parent. And the rent you can't be sitting in, let's say, a 4-bedroom apartment paying $500. Like that's not going to be protected, because it can't be a rent that's substantially less than fair market rent. There is something that folks refer to as cash for keys. They don't have to offer it to you, but if the bank comes in and says, I want to get the property back from you, we want you to move out, they have to offer a minimum of $2,000. I've had cases where attorneys walked in and said, all right, Nilda, I'll give your client $1,500 as cash for keys to the unit because we want them out. I said, you can't do that. It's against the law. It has to be $2,000. They checked with the mediator. They confirmed it has to be $2,000. So that is the minimum if they offer it, which they don't have to. Or 2 times the prior paid security deposit. So it actually could be more, but that is the threshold. And speaking of security deposits, the main purpose of security deposit is going to be to protect the landlord from damages beyond normal wear and tear. What does that mean? So if you hang up, photos on the wall and there's holes when you take out the nails, that's normal. That is normal wear and tear. That's not what we're talking about. If you broke a hole in the wall because, the door handle kept hitting a spot and it created a hole, that's beyond normal wear and tear. So that's what they could use your security deposit for. Every year, the Banking Commission in Connecticut sets the rate for interest that you can earn on your security deposit, because your landlord is supposed to put that money in a separate escrow account. They're not supposed to put it in general account mixed with their funds. It has to be a separate account. They are supposed to pay you yearly. As long as you pay your rent on time every month, they're supposed to give you your interest at the end of the year. It's not a lot of money. If you see the current rate is 0.55, not going to be a lot of money, but it's still worth noting that they're supposed to give you that money at the end of the term. How much can they ask for? If you're just graduating out of Trinity and it's your first apartment off campus, they can charge you up to 2 months of rent. That is currently the maximum. Anyone who's 62 or older, the maximum is 1 month rent. And in fact, if a person's in an apartment and they turn 62, they can get that up. If they pay 2 months, they can get the other month back, because they can only hold 1 month for 62 or older. So 2 months is a lot up front, but it is generally, it is allowable. And I see it a lot. I see it a lot with landlords. They request 2 months. So returning of your security deposit. So we're walking through, you've now paid your security deposit, you've kept your receipt, you've been there a year, and now you're moving out of the apartment. Try to make sure you're moving at the end of the lease term so you can avoid owing more rent. I always say take pictures, and if you can have an independent party walk through, it's kind of hard, right? Because if you bring a friend, that's not really independent, but take pictures. Everyone has their phones, they could take pictures. It's very important that you make a written request for return to the current owner as soon as possible. Request of the return of security deposit and the interest. And they actually just changed the law on this just last year. It used to be 30 days, but now it's 21 days. A landlord has 21 days to respond, to return your money, or account for how they used it for damages or unpaid rent. If they don't respond in 21 days, they could now put themselves in a position where they owe you double the deposit. Now, you did all this. Now what? You still don't have your money. You still haven't heard from the landlord. You can sue in small claims court if they didn't return it or if they deduct it for things you don't agree with. Small claims court, I will say, doesn't move super fast, and there's a cost to that. You got to pay a fee to file. If you don't want to do that, your other option is you can file a complaint with the Connecticut Banking Commission. It's free to do that, but they do require, for example, that you, in notifying your landlord requesting return of your deposit, that you do it by certified mail. They want the proof. They want the receipt that you paid it. They want proof that you sent the letter and that you did it by certified mail to get some kind of proof back. So that, I always say start there. I think you should start there before going to small claims. It can move a lot faster and you might be able to resolve it with the banking commission. And then if not, you still have small claims as an option. So if you have to break your lease early, you are going to be liable for any rent that you still have on your lease term. So if you're in month 9 of a 12-month lease, you still have those 3 months that you'd be liable for. However, the landlord does have to mitigate, right? The landlord can't just sit there and be upset and not try to re-rent the apartment. They have to try to mitigate the damage. You could be liable for costs related to re-renting, and you may be charged some court costs and attorney's fees. So it's a little tricky unless you're able to resolve this directly with the landlord. It's not to say you can't try to resolve this directly with the landlord, of course, in writing, but it can get expensive breaking a lease early. So just something to think about. There are some protections for elderly disabled tenants. If they get a housing subsidy, they can terminate just giving 30 days notice. It's just an exception that exists. There is also protection in state law for victims of domestic violence. They can break the lease and move on a 30-day written notice, but make sure if someone is invoking that protection that they have all their possessions out at the 30-day mark, or the landlord can then go in and remove because you just get that window of time. But it is an exception available. So that is we got through the portion on rights and responsibilities on both sides for the landlord and the tenant. And we'll move on to evictions, but I see a question. Could I stay? Oh, okay. I saw the message. Absolutely. Sure. We can chat after, no problem. Does anyone have any questions so far about the content? I hope you never ever find yourself in an eviction matter, but I believe firmly that knowing your rights, knowing about process is very empowering, and knowing all these things, it will help you even just in conversation and negotiation with a landlord. So it's just good to know these things. So kind of like what I did earlier, if anyone wants to try to answer some of these questions in the chat, do tenants get 3 months to move? Let's see, can tenants be evicted when they're ill? Can a landlord evict because the lease ended? And finally, can tenants be evicted in winter? I often have had clients that say, I have kids, they can't evict me in the winter. Unfortunately, the answer is yes, they can evict any time of year. So we'll move forward and we're going to answer a lot of these questions on the next few slides. As I mentioned earlier, lockouts are illegal. Only a judge can order an eviction, even a squatter. So even someone who came in with no right or privilege to the unit, even they have to be evicted. Lockouts are just illegal in the state of Connecticut. This is the website again that I had earlier on the screen. This is how cases can be tracked and also how documents are filed. In the state of Connecticut, pretty much everything is done now by e-filing, but of course, pro se, anyone representing themselves can also go into a court, do it in writing, and submit it to the clerk and do it that way as well. But most things are done electronically now. So these are the statutory grounds for eviction in the state of Connecticut. Obviously, the biggest one we see is non-payment of rent, but you could also have material breach of lease, meaning there's a term in there. Maybe it's a housekeeping term, for example, and the landlord did an inspection and wasn't happy with the housekeeping. That could be considered breach of lease. Okay, I see another direct question too, and I'll look at these and I'll answer these at the end. Thank you. I appreciate the questions. You can also be evicted for lapse of time. The way I explain this, if you're facing an eviction, that's the best way to face one because it's a benign reason. It's just saying the landlord saying, look, we're at the end of the lease term. I'm not interested in renewing. So that's the reason. The time has ended. Nuisance is something that is disturbing, right? To either landlord or your neighbors. Think I've had clients that face nuisance because they had loud parties, for example, right? A loud party that creates a nuisance, you can face eviction for that. Serious nuisance is basically, right? It's got serious in front of it. We're talking violence, drugs, prostitution. That is pretty heavy stuff. So, however, sometimes landlords put serious nuisance on things that we argue are not. And then it gets into this whole like technical thing, which is a good thing to have an attorney at that point, but serious is as serious as it sounds. And then there's no right or privilege. I mentioned the squatter. There's two types of no right or privilege. It could be you had a right, you had your lease, right? But you no longer have a right. Maybe they want to use the apartment for family. So you could fall into that category. The second type is never had a right. So that's going to be the example of like a squatter, someone that never had a right to be in the property. There is a very good exception called the good cause protection for seniors. And that's anyone 62 or older and disabled. And again, living in a complex of 5 or more units, they cannot be evicted just for lapse of time. It would have to be for cause because they're otherwise protected. And the basic reason for this is that it is hard to move, right? It is hard for someone who is either a senior or with a disability to move. And so if they're going to evict, it cannot be because they don't want to renew the lease. It has to be for something like non-payment of rent. You are otherwise protected. So in an eviction case, in some instances, you get a pre-termination notice. In our world, we call it a CAPA notice after CAPA versus Flores. It was a very important case, but basically it's only required in nuisance or a lease violation or some kind of violation of tenant responsibility. Basically, it has to give the tenant an opportunity to correct the problem. So if they're saying you're having parties late at night and it's a noise issue, you get this notice, you have a chance to cure it. You won't do that anymore. And then the landlord hopefully will say, okay, cured, I'm not going to move forward. There is also that 90-day notice to tenants after foreclosure that we talked about earlier. But then after the pre-termination, let's say the landlord disagrees and thinks you're still violating the rules about loud noise. At that point, they would go ahead and have a notice to quit served. And that's a necessary precondition to all evictions. It has to give at least 3 days to quit. It literally says language like, "You are hereby notified that you are to quit possession of the premises on," and it gives a date certain. It doesn't mean you actually have to leave on that date, but it starts the process. It has to state a reason, and it has to state one of the statutory reasons that was listed on the previous slide. Sometimes landlords just write a whole monologue of things and none of it really covers one of the grounds. That makes it something that we can challenge in court. Use and occupancy. There should be language on the notice to quit that talks about any rent tendered will be considered use and occupancy. What does that mean? The landlord, of course, is going to want the rent while they're trying to evict you because it is a business, right? They're still trying to get the money, but they're calling it use and occupancy because if they call it rent, it's like they're recreating the tenancy with you. So gets a little tricky, right? If you don't want to stay there, if they have the language and you pay it, they're going to keep it as use and occupancy, which is the same as the rental amount, but it's not rent. It doesn't mean you get to stay there at the end. So just something to consider. After the notice to quit and after the quit date, the landlord then can serve a complaint. And that's really what starts the eviction case in court. The return date is on the top right-hand corner. If they use the court form, that is a very important date. You have to file your appearance and answer within 2 days of the return date. It has to talk about the type of lease, the term, the reasons we talked about, that they gave sufficient notice, and it must request a judgment, the judgment being possession of the premises. The danger of not appearing or answering means that they can get a judgment against you without even going to court at all. So you can't ignore the paperwork and they don't have to serve it in your hand. They can leave it at your door, jam underneath the door. They just can't leave it in a common area, but very important to respond. God forbid you're in a position of getting paperwork. I mentioned this a little bit before, use and occupancy. They may also file a motion for that. You have 5 days to object, but if they're seeking the amount that you're already paying rent, that's going to be allowed. Tenants that I have that have subsidies, they can object if they're trying to get them to pay the full rent and not just the tenant portion. That's where in my world we'll object a lot. Then there's failure to make payments as ordered. So then the only danger if they issue the use and occupancy order and they order you to make the payments to court at that point, if you don't pay, the only real consequence is that you're going to be required to file your answer, which closes the pleadings, and that means you'll be in court faster. So if you're trying to get as much time as you can, that's going to get you in court faster, and it closes the time. So just something to consider. And then failure to answer means, again, landlord wins, no day in court for the tenant, they just win automatically. Discovery is allowed in eviction, just like any other civil case. Can be helpful. You can do it pro se as well. That's the best time to get the leases, rent ledgers, documents. Also, making sure the right person is evicting you, that it's the proper owner or lessor or the legal rep, but it is available. I mentioned the answer. It has to be filed within, the appearance has to be filed within 2 days after the return date. There's actually a number of different pleadings that can be filed. It doesn't have to be an answer, but this is where it gets a little technical, and it's best if you have an attorney at that point because they can file a different kind of responsive pleading. And not to say that someone can't do this per se, it just takes a little work. You might have a really good motion dismissed. Maybe there was bad service. I've had cases dismissed where it was bad service, where one of my clients found it, a neighbor found it in the trash receptacle. And it doesn't matter that they got actual notice, they didn't serve them properly. So we got the whole case kicked out. There's also a request to revise, which is basically, sometimes I'll file it to ask the landlord, they haven't put the lease term in the complaint. So I would ask them to revise the complaint and put that. A motion to strike gets a little more technical too. Again, I would say consult an attorney, but because there's so many other options, but an answer in special defenses is something that anybody can file and should file if they're doing it on their own, because you don't want to get a judgment against you because you failed to file something. That's why we put always file your answer if you're representing yourself. And all these forms are available on the court website. If a pleading is not filed, a landlord may file a motion for default, failure to plead, and get an order to have you out. You do get a few days after they file that, but it moves very fast. Housing moves quicker than your normal civil action. It's a 3-day pleading cycle. Every 3 days, something has to be happening. And if not, you can get a judgment against you if you fail to file your answer, for example. So it moves very, very fast. So trial. At that point, once a tenant files their answer, the court is going to schedule it for a trial. Tenants have to be ready to go on their trial date. They're going to send every case to a mediator. However, if you don't settle it, it could go to trial that same day, and I've seen it happen. Mediators can be great. Sometimes tenants work things out with the landlord. That's no problem, but if you're going to work a deal out in the court hallway, make sure the housing mediator takes a look at it before you sign anything, and that the mediator goes over it, because you don't want anyone pulling like a fast one on you. So it's good to have, they're independent. They work for the court. They're not there to take sides. They're just there to try to help you resolve it. We put a warning here. It sounds obvious, but it's important to say it out loud. You don't want to sign an agreement if you can't do what it says, because the stakes are very high. If the agreement's violated, they can get you out even faster, right? Because they don't have to start at the beginning with the eviction. They can just file one piece of paper saying you violated, and then they can get the paper they need to have you evicted from the premises. And it moves very fast from that point. If it doesn't settle, then in mediation, the judge will conduct a hearing, decide the case. The landlord as the plaintiff would go first, and then the tenant gets their opportunity to show whatever evidence they have, tell their side of the story, and they can show any photos, papers, or documents. The judge may ask questions, and typically does when it's a pro se. And then the landlord and tenant can also ask questions. The judge ultimately makes the decision. Most decisions are mailed and put in writing. Some very, I wouldn't say rarely, but sometimes they make them right from the bench. But then at that point, it's up to the judge. Which is why we settle. I would say about 95% of housing eviction cases settle, because that is the safest way. Everyone knows what they're getting out of it. And I tell tenants, if everybody's a little bit cranky, that's a sign of a good deal. That means that everyone gave up a little something on each side and they reached a compromise, right? That's a compromise. We always throw in trial etiquette, prepare for court, make sure you have copies of everything. If you have witnesses, they should be there. They may need to be subpoenaed. Get to court early, turn off your cell phone. Sounds obvious. I've had clients had their cell phones confiscated by judges because they went off. You have to, stand up when you speak to a judge and use the proper your honor language. And wearing business clothes. We've had clients once or twice that we were pulled aside because the judge didn't like what they were wearing in court, found it inappropriate. So we just always kind of put a disclaimer. You want to wear your best business clothes to court if you should find yourself in that position. So after trial, either, right, the tenant wins, you stay in the apartment, or if the tenant loses, you still get an automatic 5-day stay before the execution. That is the legal term for the piece of paper that they can use to formally remove you and your belongings from the apartment. So in those 5 days, you can file an appeal, which is we file appeals in our law firm, or you can ask for more time. In a non-payment case, you can get up to 3 months. However, you got to pay all the rent that they allege that you owe and didn't pay. So that's not really a good option, because that's a lot of money up front to just get possibly 3 months. In lapse of time or violation of lease, you can also ask for up to 6 months. But you got to show things like what you're doing to find a place. You have to have a good reason to ask for a good amount of time. You are limited to 5 days if it's for nuisance, serious nuisance, or never had a right or privilege to occupy. For those 3 grounds, you can't get more than the 5 days. So if the tenant loses, I mentioned that execution is that piece of paper that directs a state marshal to remove tenants and their possessions. The notice, they just have to give, like, again, reasonable notice, and reasonable notice has been like 24 hours notice has been considered reasonable. So we always tell folks, obviously, we don't want to see anyone in that position, but if they are, to pack things and always start with valuables first, medications, legal documents, um, heirlooms, anything of value. Because if you don't remove your stuff when the marshal comes, I promise you they're not going to use the same care with your stuff like you would. And then it goes to auction and it's 15 days to retrieve your property. Obviously, we don't like to see anyone get to this position. And over my 20 years of practice, there's, I would say, a little more than a handful of tenants that unfortunately hit this point. So we work really hard not to see it get there, but this is the process. I just briefly wanted to talk about housing discrimination that I mentioned earlier. In Connecticut, you are protected class for race, sex, national origin, disability, religion, age, marital status, familial status, sexual orientation, and source of income. We were one of the first states to have source of income protection. What do I mean by that? In Connecticut, a landlord cannot refuse to rent to someone who has a Section 8 voucher. So a landlord can't say in Connecticut, oh, you have Section 8, I don't take Section 8. There are some exemptions, like for smaller landlords, the very small units they rent, but for the most part, it is illegal for a landlord to say that. Prevented conduct is refusal to rent, setting different terms, refusal to make a reasonable modification if it's needed to accommodate a disability. They can't do that. So we have a lot of protections in Connecticut. If you need an accommodation, no limitation on how or when you make the request. Oh, I always recommend doing it in writing. What Let me give you an example. Perhaps they have a no pet policy, but you need a pet because of a disability, right? So you can request that kind of accommodation, and you would have to have an actual disability or have a record of it or being regarded as having a disability. You provide the proof if requested, and you connect the disability to the alleged violation. So if there's a no pet policy and you're in violation, but you need it because, let's say, it's your emotional support animal, then you connect it. Yes, there's a pet policy, but I'm asking for a reasonable accommodation for my disability that I can still have the pet, even though it's a violation. And then you just have to prove that the request is reasonable, because it can't be, it still has to not create like an undue burden on the landlord. But I have had cases like that, where some of my clients had, I remember a woman that had a lot of birds, and the resolution we came to was that she was allowed to keep, I think she had 5 birds at the time. She kept them because of her disability, but then the rule was, as the birds moved on, she wasn't allowed to have any more than 2 at a time. And it resolved the case, and then she remained house without an eviction. And what to do if you have a discrimination complaint: act immediately, write down as much of what you remember happened, just write it down. You can always contact us at Connecticut Legal Services, or for Hartford, our sibling agency, Greater Hartford Legal Aid. But you can contact us, or you can contact another sibling agency, the Connecticut Fair Housing Center, and that is their website. You can also file your own complaint with the Connecticut Commission on Human Rights and Opportunities. I've taken cases there myself too for clients. We also go there. That's administrative. We've had some successful cases there too, where they failed to accommodate an accommodation, and then they were financially liable to our client. Sometimes it's modifications have to be made. Sometimes they have to, pay the client money as part of the settlement. But it's a very good tool that we have in Connecticut, CHRO. Looks like someone asked what things to look out for when signing a new lease in the state of Connecticut. I would say First of all, some of them I know can be super long and seems like it has a lot of legalese. You just want to make sure you do go through it, read through it. If something doesn't seem right, it probably isn't right. So you should question it. Do a little research. If you're not sure, go to ctlawhelp.org. Our website has a lot of good information for you there. But you want to make sure the lease has terms that you can comply with. And the rent amount, the terms, who do you contact when there's an issue in the apartment? Who's responsible for whatever utilities? You want to make sure a lot of those basics are in there. It's a good question. The next question was, can you ask for changes to be made on the lease agreement before signing it? Absolutely. Or is it always take it or leave it when it comes to lease? I mean, I would say no, you can absolutely, it's a negotiation, right? You can. Now, will the landlord want to negotiate with you? That's where it can get a little tricky. But it has to be something you can live with. If it's absolutely something you can't agree to, then you probably shouldn't. It's probably a red flag, but you can absolutely still negotiate it before you sign it. Are you responsible for electrical bills for heating charges? It depends, right? Most leases, I would say utilities are, the tenant is on their own to do utilities in their name. But again, it depends, right? You may be responsible for paying the oil bill to fill the tank, but if the boiler's not working, that's on the landlord. They have to fix that. That's why it's always important to know and have in the lease who to go to if there's an issue. So you just got to make sure you read through that. Let's see, it says, what can one do if the landlord does not fix issues in time, turn on heating in the winter? Okay, after repetitive requests. Good question. The other thing I forgot to mention is in the winter, landlords, it's a minimum of 65 degrees for heat during the winter months. That is the bare minimum. If it's below that, you can actually call the police actually about that. But the easier route is always to report it to the town officials. It's sometimes called the building department. It might be the health department or the housing code enforcement. It depends where you live. They call it something different, but every town, if you call, you can figure out where to make a complaint about your apartment. If the landlord doesn't fix it within those 21 days, remember, you can go in and do that payment into court action, also called housing code enforcement. You can file that and then you start paying your rent into the court. And that's the motivation the landlord has to make the repairs because they're going to want that money. So good question. For the interest gained in the security deposit, is it required for all landlords in the state of Connecticut or it has to be, it's required. The interest, it's every year it's set, it's automatic. So it doesn't matter if it's not mentioned in the lease, they have to pay the interest. Again, sometimes it's going to be pennies. It's not going to be a ton of money. But still, if you're paying your rent on time every month, you're entitled at the end of your lease term to get that. And thanks, Lori, you put the CT Law Help website. Yeah, like it has great information. You can also, honestly, you can contact me as well. Lori has all my contact information at Connecticut Legal Services. You can also look me up on our website. It's ctlegal.org. Yeah. It's Lori, I guess you can circulate that, but you're always welcome to call me if you have a question. I know at least one person wants to stay on after, and I'm happy to do that. All right, if there are no other questions, I think I got all of them in the chat. These are great questions. Thank you guys. I hope you found this helpful. It was a lot. I spit out a lot.